Hey there, good morning. This is Shannon Lynch, your local realtor here in Charlotte, North Carolina. And today my guest in-house is Jim Surane. He's a local real estate attorney here in Charlotte. Good morning.
Good morning.
Thank you for joining me.
Yes, ma'am.
So I thought maybe today we could talk about, because this is such a hot button in, current events, is with COVID, what's been going on and how it's affecting the landlords and what the landlords can possibly do because as a real estate investor, as well as a realtor and a landlord myself, obviously this is important to me. And actually, I don't even have my rental currently. One of my two rentals is rented, but I'm honestly a little bit afraid to put a tenant in there right now. And so there's a lot of other folks that I'm friends with that are also investors and landlords, and I thought it would just be a great topic for us to kind of cover today. So where would you like to start? Do you want to kind of do like a broad overview? Actually, let me start here. How long have you been an attorney? I'm sorry, I'm off to the races this morning.
Quite all right. I've been practicing here in Mecklenburg almost 29 years.
Wow.
Doing mostly landlord-tenant law. I started as a magistrate back in 92 and then left the magistrate's office and started doing landlord evictions. And so I probably have done, it sounds crazy, but I would imagine of around $500,000 because I used to do 3,000 cases a month. So we would go into court with as many as 400 cases a day on a calendar.
Oh my gosh.
And we did that for about 15, 16 years.
So it's safe to say you're good with this topic.
Yep. Heard it all.
I'm probably and then some.
Yeah, for sure.
So what's your thoughts on what's currently going on?
Well, it's a mess. There's been a lot of activity with the federal government, with our Chief Justice of our Supreme Court, with our clerks, with our district court judges. Then, if I may, I can start with just a brief chronology.
Please, yes, absolutely.
What I'm seeing in court is a lot of the landlords that are not represented, they haven't had the benefit of reading a lot of these executive orders that have been issued either by the CDC, by Congress, by Chief Justice Beasley, and of course the governor just recently issued the order October 28th that's really going to hurt landlords
Yes.
and us in terms of processing evictions. But it all started back in March 27th. Congress passed the CARES Act, and that CARES Act was for 120 days to expire on July 27th. So we all thought the gate would open back up. Unfortunately, they put a provision in the CARES Act that I don't think Congress intended, but basically you have to give a 30-day notice of termination before you can start. So post June 27th, you had to affirmatively issue a 30-day notice, and the magistrates would not process the file without the benefit of having that notice been given.
So right out of the gate, people are getting thrown out.
That put it out till the end of August.
Wow.
So we were all kind of thinking, well, in August, things will start opening back up. During that period of time, as most folks know, the courthouse is closed on April 13th and didn't reopen until June 1st, and that was for all cases, not just evictions.
Right.
At that time, on May 30th, both Governor Cooper and Chief Justice Beasley issued orders, respectively, basically requiring that the landlords, the governor's order actually extended the moratorium an additional 21 days. And the CARES Act only pertained to federally backed mortgages, meaning your house was backed by a federal mortgage, Fannie Mae, Freddie Mac, anything like that. Governor Cooper opened it up to both commercial as well as residential and extended it 21 more days. That was on May 30th. And then Chief Justice Beasley required that an affidavit be provided. That affidavit avers that under oath that you're not a federally backed mortgage, and that has to be filed with the complaint. The biggest thing I see going on now is a landlord like yourself doesn't realize that this order was issued by Chief Justice Beasley and that it has to be filed with the complaint. So they're coming to court and they may have it, but the magistrate is saying, well, you didn't file it with the complaint. And depending on which county you're in, Mecklenburg's pretty good. We've got 4 magistrates. They're all very well-seasoned, good lawyers. But you get in some of those outer counties where you're not having lawyers do it. I'm just seeing folks just get dismissed summarily without explanation.
Wow.
And they're just bewildered. So we got to the point where we all thought post-August we'd be okay because now we're past the CARES Act, we're past the 30-day termination letter, and that the evictions would start up again. And then what has happened is the declaration, well, the CARES Act affidavits are still being required, which We're not sure why, because it's expired, but the magistrates require them
Mm-hmm.
in every county. And then everything got cleared up. We thought we were good to go. We started processing in September. They're only allowing 25 people in the courtroom at a time, so it's very, very slow. It's taking much, much longer than it usually would.
Yeah.
But then on October 28th, just last week, Governor Cooper issued an order that a landlord now must present a declaration to a tenant before coming to court. We were processing probably 70-80% of the files because the tenants weren't aware of the fact that if they presented a declaration, the declaration just says that they were somehow impacted by COVID financially.
Mm-hmm.
Very, very easy threshold to cross in order
Right.
to gain the benefit of the declaration. If you present the declaration, then the landlord is stopped immediately in their tracks. There's no argument, and the case gets pushed out till January. In Mecklenburg, they're setting declaration cases about second week of January now. What Governor Cooper just did, he issued an executive order that requires the landlords to tell all their tenants before they come to court, you have a right to fill out this declaration. And you have to give them an actual declaration. And all they do is they just sign the bottom of it. And then the landlord is also then required, once they receive a declaration, to file it with the court system.
Okay.
My guess is, based on my experience, instead of processing 70 to 80, we're now going to process probably 20% of the cases between now. Almost every tenant's going to present a declaration.
Wow.
Yeah. So, and what's happening, of course, the backlogs are just getting deeper and deeper and deeper.
Yeah.
We still haven't started calendaring district court appeals from back in March. So you've got landlords that haven't been paid since January and February. And I've been doing this so many years. I've never, not even close, seen the ledgers like I'm seeing today. I'm seeing a lot of 5-figure ledgers. That's 10,000 plus.
Right.
In most of my cases, they're 5,000 and up. And a lot of these folks, these landlords, they don't have the capacity to absorb those kind of losses.
Correct.
And they're struggling. So
How do you see that going? I mean, because right now, from a realtor standpoint, and actually, I did put on one of the Facebook groups for it's on the investors group for them to submit questions. So I thought we could kind of cover some of the questions that they've submitted. And one of the things I'm hearing landlords saying is they're doing month to month versus doing like a yearly lease. How does that affect? Does that make a difference?
absolutely, that's a very wise decision to make. Based upon the fact that this has been in place since March, almost a large percentage of all the cases, landlord cases, have aged out. That means the leases have expired. So what we're doing now is we're meeting with our landlords, and we're doing little seminars telling them that you're only banned from filing from failure to pay rent. That does not preclude you from proceeding for what's called a holdover
Mm-hmm.
and sending out the appropriate notices and then terminating the lease based on holdover. The magistrates get it. They're not fighting it. They understand the lease is expired, so you're not protected by any of the executive orders. You're not protected by the CARES Act. You're not protected by the CDC order. You can proceed on that and or any other violation of the lease.
Where does that fall amongst the caseload? I mean, so even if you're in the right and it's a holdover, how long is it going to be before you can actually even get your case heard?
Well, actually, we're being heard quickly now because they've deferred so many of the money owed, which is the bulk of most landlord-tenant evictions.
Mm-hmm.
And so there's kind of a wide open forum now where so many cases are getting pushed out that if you do come in for a holdover or a criminal activity, or you come in for, we got a lot of cases we file, some of our landlords require tenant insurance. We're filing for breach of the lease because you didn't provide your tenant insurance, and they're going through. It's the only way to fight back right now. When Governor Cooper issued that order on October 28th, we're gonna get pushed way into January. That's where you're going to see a backlog for money owed cases and trying to get those processed.
Mm. Let me go to the questions. Lori says, and she may just be, let me see. She says, I do mostly month-to-month leases for several reasons. With COVID, it seems wiser than usual. Is there any COVID-related restrictions on evictions for a leased holdover? A 30-day notice that their lease would not be renewed would be given per lease requirements regardless of payment or non-payment. Is that enough information for you to give an answer to? Sure. Okay.
That's very wise. I think that landlords right now, if they're going to let their premises. Do not do any long-term leases. You're not required under the law to give a 30-day notice. What I tell our landlords is if the lease expires, shorten the notice up to 2 days. You're allowed to contract away. The general statute's 42-14, but you can contract to extend or shorten that period of time, and you might as well make it as short as possible so you have the discretion not to have to wait an additional 30 days where you're not getting your rent.
Okay.
And get you in the courthouse quicker.
Okay. Alex says, I just did 2 lockouts about a week ago before the executive order for non-payment. Have heard you should be able to evict for other reasons. Also, normally you don't need a reason to evict on a verbal lease. Is that still the case?
Nope. You have to have a reason to evict on a verbal lease. The challenges with the verbal lease are there are no conditions other than you pay rent. And if your condition is that you pay rent, you're going to fall under the CDC's order. And you have to, under 42-3, the statute, you have to provide a demand 10 days before you file the complaint. It's always advisable. And we have all the forms, and we can post them on anything you want to help the landlords that don't have the benefit of counsel. The forms that we recommend strongly. We have a lease that has taken us 15 years, sort of an evolutionary process of dealing with legal services over the past 2 years has been extremely challenging. They are filing counterclaims in many, many, many cases. And they're asking for, I've tried several cases over the past year where the damages they're seeking are in excess of $100,000. They pursue this unfair debt collection complaints. We've been very successful. I think the best they've done is maybe $500 on a lot of those types of counterclaims. The judges are just not buying into it. But it's very expensive for a landlord to retain counsel, and they have to at that point where they're being sued for that much money. They've got to get counsel, and they're going through a full panoply of discovery. That would be depositions. They're going through written discovery. Things that we would normally do in a complex superior court case are now being done in a summary ejectment eviction case. And our poor landlords just can't afford to do that.
Right.
And it draws it out, and normal summary ejectment cases are now taking 4 months.
I mean, from a realtor standpoint and a landlord standpoint, I do wonder when you think about the cause and effect of all of this. I mean, at some point, the landlords are either going to wind up selling some of these properties or going into foreclosure if they can't cover it, and if they can't get the non-paying tenants out, right?
It's true. The upside of right now in this area is a lot of our landlords have these discussions with me. Their pro formas are going to be so off that they're never going to recoup. When you get up to 10, 12, 15,000, I had one 22,000. And so with this market the way it is, where you put a house on the market, especially a rental, there's so many large REITs and the rest of them buying things. That's the only way they're going to balance that pro forma back is to sell the property, unfortunately. There's no governmental relief for the landlords. There was initially for deferrals, deferments and forbearance agreements, but all that's kind of passed now, and we're still not able to evict. So some of our landlords are selling. I think if they get to the point where they're looking at foreclosure or their credit being affected, they call on someone like yourself. These properties are selling, especially investment properties, within a week of being listed at top dollar.
Right. Where would you like to go from here?
Well, I would suggest things have gotten really dicey at the courthouse with legal services.
Oh gosh, yes.
Yeah, and so what's happening? It's something that we're trying to pull together as landlord attorneys and as landlord organizations to stop some of it, because what they're doing is, and this has never been done before. Again, I've been doing this for almost 29 years, and I was, as a magistrate, would never tolerate what's happening. But their legal services went for probably the last 25 years from 3 lawyers that handled their landlord-tenant related matters to now 12 lawyers. So you've got 12 lawyers, which would really be the largest landlord-tenant firm in Mecklenburg County, with not enough to do. So what they're doing is coming to the courthouse. They're then being given a forum by the magistrates where the magistrates are saying, if anyone here would like the benefit of free legal aid, we'll hold up calendar call, go outside, talk to these lawyers, and then half of them come back in represented, and those half immediately ask for a continuance of the case, and the case gets continued, and then they start what's called the discovery process, which is depositions and interrogatories and requests for admissions. and request for production of documents, and you've now turned what was a summary ejectment case, which is what our legislature intended to be summary, that word gets lost, and we're drawing into these 4-month-long full legal battles over a tenant who really didn't pay rent, really doesn't have any viable defenses, and we're having to go to war with legal services, and we can't seem to get the clerks and the rest of them to stop allowing them to do this.
Right. And I feel bad for the people that are affected by COVID that do have a legitimate reason, but there are so many people that just know how to work the system, and this is a big loophole. I feel this is when people wound up getting that $1,200, I just don't understand. I just feel like the government could have handled this whole thing better, and I understand it's easy to armchair quarterback, but you're going to give everybody checks for, what was it, $1,200? And I don't understand why instead something wasn't put in place that either people had to fill something out and it was applied towards their rent, towards their living expenses. And instead, you read articles about how all of a sudden, sales were up at Walmart and at Target. Like, everybody thought it was Christmas when they got that $1,200 check, instead of applying it towards basic living needs, which is where it really should have gone.
And right now, the way that this is all set up with this new CDC order and with Governor Cooper's executive order, they don't really need to be too seasoned to just simply turn in a declaration. You just sign your name and you turn it in, and you're in that property free until mid-January at best. And then if you appeal, we're looking at probably March or April. What we have been doing, though, is we've set up forums and they've been very successful at the Fairfield Inn across from the courthouse. We bring several lawyers in, some of our larger institutional landlords, and our landlords that have 10, 12, 15 properties. And then we have Charlotte Housing Partnership there. Charlotte Housing Partnership has had, and probably about a month now, about $10 million they had to get rid of by December. So when we brought them in, we had a settlement forum, basically, where the tenants would agree to waive any counterclaims, legal services. We invited them. So the tenants were represented. And I would say virtually not every case, but 95% of the cases got settled and funded. So these landlords that had $5,000, $6,000, $7,000 balances got checks from the Charlotte Housing Partnership, so it got them current.
Really?
And now they're not only getting you current from March forward, they're willing to give you 6 months rent into the future if you qualify.
Well, that's a wonderful piece of information.
Very easy to qualify for a tenant.
How do you qualify?
The only qualification is that you have to show that your income was affected as a result of COVID, and that could be you lost your child care, it could be you got your hours cut back, and so it's a very low threshold to qualify, and the money's there. It's still there now. We're processing them every day as fast as we can to get these landlords as much money as we can before it runs out.
Yeah, because if we're not, at this point, it's going to be so hard to be made whole again. That how do you, like you were saying about the pro formas, it's just going to be virtually impossible to recoup what you've lost. And so what would you, at this point, recommend if you have a vacant property and you're thinking about, obviously renting it, because it doesn't make sense to just have a property sitting vacant. What do you believe is the smartest course of action as far as, finding a tenant and putting a new tenant in your property?
I would I would have a very sound lease, whether you use the Realtors Association lease, which is a good lease, or our lease or some lease, but don't do a handshake or a lease at all, and do a very short term, month to month. You can do week to week, month to month, but do not do a year's lease, or you're going to get brought right into this whole
mess.
Yeah, you can't do it. If the tenant stops paying rent and you don't have a holdover argument to make or cause of action, then you're looking at dogs, unauthorized occupants, drug activity, something else that you can reach and latch onto. But oftentimes that's hard to do. The easiest way to do it, to control the situation, is to have a short-term lease.
Okay.
And then once this is over, you can go back to the tenant and say, now I want a year.
And what's your thoughts on, I know a lot of landlords will do, first month's security deposit and then the first month's rent. Do you think it makes sense to, because I've seen, and I've had it happen myself, where they'll decide they're going to use that security deposit as their last month's rent, even though that's not what they're supposed to do. Do you think it's a good idea to, let's say the rent is, normally, I don't know, $1,800 a month, maybe make your security deposit significantly higher in order to, and how high could you go? Is there a bar on that?
There is. Under the general statutes, 42-50, you're not allowed to do that. You can get 2 months on a year lease and 1 month on a month-to-month lease. And then on a week-to-week, I believe it's 2 weeks. So yes, under Chapter 42, there's a cap, and you can't go over that cap. A lot of our landlords don't realize that you have to put that money into an escrow account.
Correct.
It becomes important if the case ever gets tested and tried. So you can only collect what the statute provides. And if anyone has any questions about any of this stuff, we've written up all kinds of summaries on everything you can imagine that we can just post.
Where would they find that?
You just call my office, or you and I can talk, and
Okay.
I can post whatever you need. A lot of these letters they need to send out pursuant to the CARES Act, they need to be written correctly.
Mm-hmm.
And if you get a declaration, the penalties for proceeding against the declaration is $100,000 and 1 year in jail. And if by chance the tenant were to die from COVID, it's $250,000 and 2 years in jail.
Oh my gosh.
If you proceeded to evict in contravention of the actual orders that have been issued.
You mentioned seminars that you do or your firm puts together. How would people find out about those and be able to attend those?
We're getting ready to do another one. I would get a list, a mailing list from someone like your organization, and we would notify you of when it's coming.
That'd be wonderful.
And then we orchestrate the housing partnership so that we qualify all these tenants. The landlord has to qualify, oddly enough, also, but we qualify the landlord, we qualify the tenant, we get all the forms done before we get to the forum. And then it's just a matter of doing settlement agreements. The settlement agreements have become extremely important because it insulates the landlord from legal services coming in and filing counterclaims, which really mess things up in terms of proceeding with a case in summary ejectment.
Yeah, I just think the whole situation is sad, but I just think it's incredibly tough on small landlords that only have a couple of properties that, this is a way that they're trying to basically create their retirement for the future or something along those lines. And, nobody expected this or saw this coming. And you could do everything right, and you're still going to now potentially wind up upside down. I mean, I have quite a few friends that, have a number of properties, and, and so many of them, they've got people in them and they're not paying. And so what do you do?
Well, hopefully they would reach out to our office, because our website now has all of the applications online. It doesn't take a tenant very long. They do have to follow up and produce the documents that the housing partnership needs. Mm-hmm. But the tenant still owes the rent, even though all this stuff is going on. The governor's order is very clear, as well as the CARES Act. You owe that rent.
So it's not a get out of jail free pass. You don't just not pay and you're done. At some point, you're going to pay.
Yeah, so it could be a monetary judgment at the end of the day. So the tenant's incentive to participate is not to have a judgment against them at the end of the day for $10,000 plus in past due rent.
Do people take that seriously? Do they understand the repercussions of that on the tenant side? Do you think that's clear?
It depends. Some tenants, no.
Yeah.
But the tenants that are certainly, I would say, anywhere 1,000 and above in rent take it very seriously, because they can't go somewhere else and get another landlord to let to them if they see a $10,000 judgment for past due rent. You've got a very serious ding on your application for rent if you haven't paid your last landlord $10,000, and it's a matter of record now.
Yeah.
So that's their incentive to reach out to the housing partnership. And I understand they just got more funds in, so if we can get folks in, landlords and the tenants have to participate, but we can get a lot of these funds recouped, and there's no obligation to repay it. It's just money that the government's handed over to landlords. Yeah, you just go to our website, and it's very easy to click through, and the tenant, we do the same. Once you tell us what tenant you want, the tenant goes to our website, they fill it all out. It gets sent into the housing partnership. When we have the form, we do the form so that we can mitigate exposure to our landlords from legal services and counterclaims. And, So it's a great benefit to the tenant, and in consideration for that benefit, we ask that they don't start filing what we refer to as frivolous lawsuits against landlords.
Do you see people being receptive to this?
Oh, we have large forums where if I call on one of our properties that we've got one next month that has, what'd you tell us, 98 files, 100 files in default, and they're going to process them all. They just got hit with this October 28th order, but they're all going to come to the forum because we're going to try to get them all their money, get their ledgers squared away, and then they have a little more patience to wait until January because they're getting 6 months now in advance and all the way back to March. There's a lot of money out there.
So if people don't take part of that, I mean, going back to cause and effect, how do you see this being more people being homeless? Do you see this being more people, being foreclosed on? What do you see the potential, outcome and results of all this being? And I understand nobody has a crystal ball, but from your perspective, where do you kind of see things going?
Well, if we were back in obviously in 2008, I would say it would be a mess for landlords. But right now, the market in Charlotte area is such that I do have landlords doing this, that they're getting challenged from their own finances because they depended on that income from the properties, and so they can list and sell the properties in a matter of a week or two at the highest price, and perhaps recoup a lot of the rent arrears that they lost during the course of the tenancy.
Well, here's the thing, right? Let's say I'm a landlord and I've got a triplex and I've got 2 out of the 3 tenants not paying the rent, and so I'm going to go ahead and I'm going to put it on the market to sell it. The new owner has to honor whatever lease is currently in place, if there is a lease in place, right? So, but if there's not currently a lease in place, I mean, so what recourse does the new owner of the property have going forward?
Again, that would depend on the nature of the lease.
Because they have to honor the lease, right? They have to.
Yeah, well, yes, probably. There's our lease, no. If we sell the property, we have the discretion of terminating the lease within a 30-day period of time. There's nothing unlawful about that.
I think I need to get a copy of your lease.
What we do with our lease is it's a fluid document because I go to court and deal with legal services on a weekly basis, and they come up with another argument, and we incorporate.
You're constantly tweaking it to, understood.
Yep. And there's some of our landlords that, thank God we have it in there because they've been hit really hard by legal services.
3 minutes. Is there anything else you'd specifically like to cover that you have on your list of things?
I don't think so. I think that.
Of course, and I'll end off on how people can reach out to you.
Yeah, if they would, because we've got all the documents that we can do, and they're not hard to fill out.
Right.
It's very simple, but and some of them have to be done contemporaneous with the actual filing. The 30-day notice has to go out before you can file, and it would be very helpful for them so they don't go to court. Some of the landlords come to me after they've been dismissed 2 and 3 times, and they don't understand why.
And they've already lost a lot of time.
Yeah, months.
And a lot of money. So what would be the best way for them to reach out to you? I know you mentioned you also have a website.
We got a website. That's probably the best way because you can set up an appointment, a phone conference. You can ask me for forms. You can whatever you need. We're there to help landlords.
Okay. And what's that website?
Oh, goodness. I think you asked me that. I'll get it to you.
You have people for that, I know. Stephanie asks, is it constitutional to not be able to challenge the tenant's affidavit in court to validate their claims?
It's not a constitutional issue. The magistrates in Mecklenburg, I feel the same way she does.
Yes.
It upsets me when I get a declaration on the day of trial. So I have often said to the magistrate, I'd like to examine the witness regarding the merits of the declaration. They, of course, are not opposed to not telling the truth with respect to my questions and their answers. And as such, we don't get very far with that examination. It does help me, so when we get back into court, I can pin them down with respect to the answers that they gave. But all they have to do is say, my hours were cut back at work, and that's generally what I hear, and that gets them right out of it. The governor's last executive order did allow for that. Before that, the CARES Act was silent, his orders were silent, but now it affirmatively states that we can challenge the declaration. And it doesn't say how, but that would take another hearing in and of itself. And we would have to do some level of discovery, meaning we'd send you a request for production of documents, and you'd have to show us, prove to us that, in fact, you lost income associated with COVID. Now we're probably into late December before we were to get all that stuff back, and we could be filing in January. So it's not a practical solution to the problem.
Yeah. Okay. Well, Jim, thanks so much for joining me today. I really appreciate it. This was incredibly informative and interesting, and I wish it was a more positive topic that we could have covered today, but it is important, and a lot of people are kind of out there floundering and wondering what recourse they have and what they can do to kind of protect themselves. So thank you for providing such great information. I appreciate it.
Yes, ma'am. Thank you for having me.
Have a great day.